Mr. Chairman. I yield myself as much time as I may consume.
The gentleman is recognized.
Thank you, Mr. Chairman. I rise in support of my amendment to H.R. 4776, the SPEED Act, which will improve the bill's judicial standing provision to limit frivolous lawsuits and ensure projects are not delayed by radical activist groups without actual material harm to themselves. This amendment makes a simple but important clarification. It ensures that only material, physical, or property harm, not purely aesthetic, recreational, or emotional interests, qualifies someone to challenge a federal agency action under NEPA. As established by the bill we are considering today, NEPA is a procedural statute. Its purpose is to require federal agencies to disclose and consider environmental effects before taking major actions, not to confer substantive environmental rights or to serve as a tool for endless litigation. The amendment aligns NEPA's judicial review provisions with that core purpose by anchoring standing in concrete, legally cognizant harms rather than subjective or generalized interests. By focusing standing on tangible harms, this amendment helps prevent NEPA from being used as a delay tactic in every dispute over administrative decisions, a tactic that too often slows necessary infrastructure and energy projects without materially improving environmental protection. It ensures that courts remain a venue for adjudicating real disputes where plaintiffs have demonstrable stakes while preserving agency and judicial resources for the most serious and legally grounded claims. At the same time, this amendment does not eliminate judicial review or impede legitimate challenges where there are real impacts. Stakeholders with substantive claims under existing environmental and land management statutes will continue to have full recourse to the courts under those laws. What this amendment does is reinforce NEPA's role as the procedural check that it was intended to be. For these reasons, I urge my colleagues to support my amendment to bring greater clarity and balance to NEPA standing and to promote a more efficient and predictable permitting process consistent with both environmental disclosure and responsible development. Thank you, and I reserve the balance of my time.
The gentleman reserves. For what purpose does the gentleman from California seek recognition?
Thank you, Mr. Chairman. This is a pretty good example of how even when Team Extreme puts together the most dramatic rollback of America's most important, yes.
Bend. For what purpose does the gentleman from California seek recognition?
I rise in opposition to the amendment.
Is recognized for 5 minutes.
Thank you, Mr. Chairman. So as I was saying, this is a perfect example of how even when Team Extreme puts together the most dramatic rollback of America's most important bedrock environmental law, it's not enough for some factions within the Republican conference. Now, I do oppose this amendment because at its core, it is built on a tired trope. The trope that NEPA litigation is some huge driver of frivolous litigation, and an argument that we hear all too often to justify more and more limits on judicial review to make it harder and harder for the public to participate in the review process and to help oil and gas and other polluting projects. But the facts do not back up this story that we keep hearing. One recent study from the University of Utah found only 1 out of every 450 actions subject to NEPA are ever even litigated. That amounts to 0.23%. And according to a recent Congressional Research Service report, and I quote, historically fewer than 1% of federal actions subject to NEPA have been litigated. So that's important context. The idea behind this amendment that we need to keep layering on more and more restrictions to shut out the public, to eliminate legal challenges, to stop frivolous litigation is overblown, especially in the context of an underlying bill which already imposes dramatic new barriers that make it almost impossible to bring a case to court. Among other hurdles, the underlying bill says you have to have commented during a comment period, even as the Trump administration is restricting the opportunity to comment. It also requires that your comment has to be unique. Now, this is a new term of art. It doesn't exist in current law. We don't even know what it really means. But presumably, if anyone else has submitted the same comment, has flagged the same problem with a federal action, you're out because your comment is no longer unique. And to add a cherry on top of all of that, even if you get into court, the SPEED Act would bind judges, forcing them to allow even dangerous and illegal projects to proceed, making the judicial review process extremely hollow. So judicial review is a cornerstone of democracy, Mr. Chairman. When the government makes a bad decision or an illegal decision, I would hope we could all agree there are times, because the government doesn't get everything just right, that citizens need to be able to challenge that action and hold the government accountable to make sure the law is followed. Access to the courts is a backstop for communities who are left out of the NEPA process to make their concerns heard and to ensure that federal government actions properly consider environmental impacts. And though we've heard a lot of fear-mongering about frivolous lawsuits, there are already effective safeguards in place. All plaintiffs have to demonstrate they've actually been harmed by a project to have standing, and NEPA will be meaningless unless there is a way to enforce it when the government does something harmful or illegal. That's what this is all about. I urge a no on this amendment, and I reserve.
The gentleman reserves. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. You know, any frivolous lawsuits is one frivolous lawsuit too many. It's just not appropriate when we have legitimate actions to improve our economy and to make sure that America moves forward. You know, Chairman Westerman mentioned the 11 years that it took to build the Atlanta airport in my home state. You know, really 18 months to actually break ground and build the airfield, but 9.5 years for permitting. You know, that's just not acceptable. The Pentagon was built in just a little over a year, all right? That could never happen today simply because of the permitting process. And I reserve.
The gentleman reserves. The gentleman from California is recognized.
Thank you, Mr. Chairman. I think we've found some common ground. I hear that any frivolous lawsuit is one too many. So I just want to remind the gentleman that maybe one of the most prolific frivolous litigators in history is in the White House right now. I want to remind him about the raft of frivolous lawsuits challenging the 2020 election results, resulting in many cases, not just in losses in court, but in the disbarment of some of the Republican luminary lawyers like Rudy Giuliani. So, you know, if we pretend to care about frivolous lawsuits, I know consistency's out of fashion these days, but we should really mean it. I reserve.
The gentleman reserves. The gentleman from Georgia is recognized.
Thank you. Thank you, Mr. Chairman. You know, I think the Keystone XL pipeline is another example of frivolous lawsuits and the years upon years it took, and yet that pipeline still is not functional in its entirety. And I reserve.
Gentleman reserves. Gentleman from California is recognized.
I reserve.
The gentleman reserves. Gentleman from Georgia.
Thank you, Mr. Chairman. I am prepared to close, and I simply want to read what my amendment says. Page 26, line 8, insert, which shall not include aesthetic, recreational, or emotional interests unaccompanied by material, physical, or property harm after final agency action. That's concrete, and that's what, and therefore I encourage all my colleagues to vote for my amendment, and I yield.
The gentleman yields. The gentleman from California.
Thank you, Mr. Chairman. We should be against all truly frivolous things, not just frivolous lawsuits, frivolous legislation masquerading as permitting reform, frivolous amendments, frivolous distractions at the end of probably the most unproductive Congress in American history this year at a time when the American people are struggling. That's what's truly frivolous. I oppose this amendment, urge a no vote, and yield back.